Yo, make sure you got your paperwork straight. I got Mickey the Truth.
Let's get one thing clear. This your girl, Mickey Truth. South Carolina, 803 to be exact. What's up, y'all? It's your girl, Mickey Truth, aka the Queen of Paperwork, and I am back with another video. As always, all information contained in this video is for entertainment, educational purposes only. All information used in this video is per the Fair Use Act, and any conclusion that you draw is on you, not me. So,
the loudest is the weakest. Give a fuck about what they scream.
all right, Truth Team. So I do have a little update for you. All right. Now, earlier today, shout out to everybody that put up on the live. We back at it tomorrow for day 4 of Kenneth Copeland's, aka Lil Woody's testimony in the YSL case. Okay. Now, Gotti's lawyer surprised us all today when he came forward with a motion for the judge to recuse himself from the trial. Okay. And as we already know, Judge Glanville was like, nah, denied. Now, he did have a little rebuttal for the judge, and ultimately the judge said he was going to put something in writing, all right? So, Megan Cuffniff, the journalist that be up on her shit for shit show, okay? From the Tory Lane case to the Trump case to the damn ASAP Rocky case, all that. I think this is the ASAP Rocky. But anyway, she actually went live with him, and he gave a little update on what's going on as far as the motion for recusal and how he feels moving forward with what possibly was said in that hidden meeting, secret meeting, or illegal meeting, if you ask certain people. So let's get into it. Y'all let me know what y'all think in the comments. I'm out.
You could address Georgia state law on when judges consider their own recusal motions, if there's different standards for that or how that works.
Yeah, there's a very clear procedure in the Uniform Superior Court Rules of Georgia of how a judge is supposed to deal with a motion for recusal. So when it's presented to the judge, which is what I tried to explain to the judge today, when it's presented to the judge, he's supposed to take a look at the motion and see if it's timely filed. We have certain time requirements, like you have to file it within 5 days of whatever incident that you learned gave rise to the recusal. It's supposed to be filed 10 days before trial begins, unless you have good reason. In this case, we think we have good reason because we're 18 months into trial and this just happened. But once he determines whether it's timely or not, then he looks at the affidavit. So you have to have an affidavit, and the affidavit has to be very specific, which is why the affidavit, if you look at it that I submitted, has a lot of detail of what we believe happened, or what I believe happened. So if that's sufficient, then the judge has to assume everything in the affidavit is true. And then he has to look and see, assuming everything in the affidavit is true, would that merit recusal? And if it would, he has to refer that out to another judge to look at, to make a determination.
Recusal from the recusal motion, basically. Would it warrant his recusal, or is the standard, would it warrant his recusal from considering his recusal motion?
No, the question is, would it warrant his recusal from the case?
Okay.
Because in Georgia, the judge does not consider their own recusal motion. Basically, and this is going to be the wrong word, but basically, if you make a prima facie case on your pleading, on your motion, that recusal is warranted and it's done in a timely fashion, and I'm oversimplifying it, but then he should refer it out to another, in Fulton, it would be another panel of randomly selected judges to make that call on recusal. Now, I believe the case could proceed, as I read it, while the recusal decision is being made, but that's a little unclear.
Well, I had to run it back real quick. Now, y'all heard what he had to say as far as the recusal. Well, listen to what he had to say as far as what possibly was said in this quote-unquote secret meeting. Check it out.
Seems like there's a lot of stuff in there about Donovan Thomas's murder, which is really why Woody was placed where he was placed in his witness order, is we're right in the middle of hearing about all that. And your client is actually one of the ones who's charged not only with the RICO conspiracy, which includes Donovan Thomas's murder as a overt act, but he's actually charged with the murder himself. He and Shannon Stillwell, right, who were both on trial.
That's correct. There's several people charged with that murder. 2 of the people charged with the murder, including my client, Diamante Kendrick, are in the trial right now. Mr. Kendrick did not commit that murder. And I think that when all the evidence is heard, the jury will come to the conclusion that he's not guilty. But we're just very troubled by what we learned happened on Monday, especially some of the things that that was told to me that the DA's office did. I don't believe in the presence of Judge Glanville, because I don't think he would put up with it. But what the DA's office allegedly said to Kenneth Copeland is really troubling.
Yeah, you said you don't believe in the presence of Judge Glanville. Are you questioning like whether he allowed prosecutors to just talk to Kenneth Copeland alone, or what did you mean by that? Little shaky connection here, but maybe we can get into the. Can you talk about what is the most alarming thing that you heard about that went on in the meeting, other than just the fact that the meeting took place?
Well, yeah, I mean, we can get into the fact that the meeting took place and that we weren't notified of it, and we weren't made aware of it before, during, or after. If it wasn't for this source, we probably wouldn't even know it happened. I guess one of the more troubling things is hearing that in the course of the meeting, I know there's so many troubling things, but hearing during the course of the meeting that Mr. Copeland told the DA's office that he basically, if they insisted on putting him on the stand, he would just get up there and lie. And what we were told is the DA told him, "Yeah, you lie. We're not gonna prosecute you if you lie." And then he said, "Well, I'm going to get on that stand and say that I killed Donovan Thomas," which, I mean, he may well have killed Donovan Thomas. I'm going to get on there and say that, and the DA's response was, "Well, if you say that, we are going to prosecute you for perjury in that case and false testimony."
For perjury, because
because they believe he did not kill Donovan Thomas.
Yeah, and that's their whole case. If he really did kill Donovan Thomas, then they'd have to drop the charges, or if they had any knowledge of that. But that's the kind of thing that's an exculpatory statement under Brady versus Maryland, right? Which is what Max Shard raised before court let out today. I mean, those statements are pretty crucial to you, right?
He's raised it multiple times and asked that if there was any additional Brady material that we be provided with that, any Brady material that may have come up in that meeting. And so far, we have not been provided with any Brady material that may have come up in that meeting. So perhaps our source didn't relay accurately what happened, or I don't know what's going on with that Brady material.
What was interesting to me was that, I mean, like has been established, you were not going to find out about this meeting unless Brian Steele had learned about it from somebody who he won't disclose to Judge Glanville. And what I've heard is, ex parte, it was, a lot of people say it was inappropriate to have this meeting in the first place, but to have an ex parte meeting like this and not notify the other side is just totally wrong. But what was alarming to me was Glanville's answer to Max Shard that he's still combing through everything to see what's releasable. So he seems to acknowledge that there could be stuff in this conversation that's releasable, but if he had it his way, you guys still would not even know about this conversation. Is there anything you can say to that, or is there any kind of talk amongst the attorneys about that?
Well, I'm not going to go that far. I don't know that at some point the judge may have notified. I can't get into his head to know that absent our learning of it Monday, he wouldn't have told us about it. But and I don't want to make that guess.
Okay.
But the judge's position on providing us with that transcript has changed over the last 3 days. I believe initially when Max requested that on Monday, it was a flat out no, that the Court of Appeals would get that, and then they could make decisions based on that. And then I believe Tuesday it was some version of that he is considering it, and then you just relayed what the judge told Max today about it.
Yeah. And for people know who they're hearing from. It's Doug Weinstein, who is Yak Gotti's lawyer. He's the one who brought the recusal motion against Judge Glanville today. And we talked a couple nights ago, and you'd said that you were going to be writing something that night. Was that the motion that you started writing that night?
Yeah.
Loudest is the weakest. Give a fuck about what they scream.
Holla!
I Shout out Mickey. Mickey, you gonna be big. Like
Yeah, I
Gotti.
love.
Trying to conquer the world, coming from where I come from. They down